My name is Emily Brown, and I'm the founder and principal attorney of Elevate Justice U.S. Immigration Law. We're a private law firm specializing in immigration compliance and federal litigation. And welcome back to your Wednesday Immigration Compliance Corner, where we talk about the latest topics in immigration compliance, including I-9 and E-Verify. So today's topic, we're going to be talking about anti-discrimination laws. While a lot of employers feel the need to be extra cautious to ensure that they're not inadvertently hiring unauthorized workers, sometimes being too cautious can be held against you. So before we dive in, everything that I'm sharing today is general educational information only. It's not legal advice. Immigration law changes frequently, so for guidance tailored to your business, consult a qualified immigration attorney. Employers have a large fear of hiring unauthorized workers, maybe even without knowing it. And so sometimes they overcorrect. They might be extra careful by requesting extra documents, by scrutinizing the documents that are presented in a wrongful way, or just by overly scrutinizing foreign hires in general. So there's a few things that you need to look out for to ensure that you're not violating discrimination laws. ICE is not the only agency that enforces I-9 compliance. So when it comes to anti-discrimination laws, the Department of Justice and the EEOC under Title VII can enforce different violations when it comes to I-9 verification, and that would be related to discrimination law. Under the Immigration and Nationality Act, you're not allowed to discriminate based on immigration status or national origin, and there are similar rights under Title VII, and EEOC would enforce that. There's the three most common types that unfair document practices could take place that could lead to a discrimination claim. It's asking for more documents that's needed, demanding a specific document, so saying you're only going to accept a List A document, or rejecting a document that looks reasonably fine. There's a big surprise, though. What the employee wants to show you, like, that is what is required for I-9. They are allowed to choose which documents they present from either List A or List B and List C. Steering that choice is a violation, even if it's with good intentions. So there are other situations where if this comes to play, that there would be issues where the employee could allege that you have violated discrimination laws based on national origin. When it comes to them raising a concern or filing a complaint, you're also not allowed to retaliate against them. So a common pattern is there's a fumble issue when you're completing the I-9, the employee speaks up, and then the reaction becomes then claimed to for discrimination. So you have to be careful there. The stakes are really high when it comes to discrimination law with the I-9 verification process because, again, it can be prosecuted by the Department of Justice and the EEOC. The other way that discrimination can pop up in the I-9 compliance arena is by asking for verification documents before or too early in the hiring process before an offer has been extended. So you're only allowed to ask about verification documents when you're completing the I-9, and you can only start completing the I-9 after an offer has been made to the potential employee and that offer has been accepted. Obviously, Section 1 of the I-9 has to be completed by the employee's first day of work for pay. You can do it earlier, but you cannot do it during the interview process to try and weed out to see if that person has valid authorization in the United States. The only thing that you can ask is if that individual is authorized to work in the United States. And then it has to stop there. You can't ask about documents or anything like that until the offer has been made and then the offer has been accepted. So discrimination law can be tricky. A lot of people in the I-9 space sometimes maybe overlook it because you do want to be overly cautious. You don't want to fall into the trap of accidentally hiring unauthorized workers and then getting in trouble with ICE. But that could then expose you to violating discrimination law. So if this is an area where you want to feel more confident before you have any issues with DOJ or the EEOC, I will cover this topic in greater detail in my inaugural HR I-9 compliance cohort, which is going to be a live training with me It's 5 live sessions on Zoom, and they'll be recorded, and you'll have access for 90 days if you're unable to make the live recordings. And it's essentially a in-depth training with an actual immigration attorney. We'll do live Q&As afterwards as well, so we can go through some of your real live examples, and just help you support you through your professional development as an I-9 specialist in the HR field. If you complete the program, you will also be eligible to self-report to SHRM or HRCI for educational credits as well. So since this is the inaugural HR I-9 compliance cohort, the very first one that I'm offering, I am offering at a special founding member price at $997 for the full session. After that, the price will be increasing for future cohorts. So be sure to save your spot. I'll drop the link in the comments, but happy to answer any more questions that you may have about discrimination law, and how it interacts with I-9 compliance. So again, my name's Emily Brown, and I can't wait to see you next week at our Immigration Compliance Quarter. Have a great day, everybody.